use this time wisely, right? We often say it, but 120 days is not that much time to prepare. Um, don't assume any of these litigation challenges are going to be successful. Until you hear otherwise, presume September 4th is the deadline.
Welcome to Mission to Grow, the small business guide to cash, compliance, and the war for talent. I'm your host, Mike Vannoy. Each week, we'll bring you experts in accounting, finance, human resources, benefits, employment law, and more. You'll learn ways to access capital through creative financing and tax strategies, tactical information you need to stay compliant with ever-changing employment laws, and people strategies you need to win the war for talent. Mission to Grow is sponsored by Assure. Assure helps more than 100,000 businesses get access to capital, stay compliant, and develop the talent they need to grow. Enjoy the show. The FTC has ruled on non-competes. This is an area for businesses, this area of non-competes. I think increasingly over a multi-year span, non-competes have been less and less enforceable. But now the FTC has weighed in, and the rules are pretty black and white. I think there's some important ramifications here for business owners that we need to understand. Got the perfect guest for it. If you're a regular watcher of the show, you know who this is. My guest today is an attorney. He's got extensive experience defending class and collective action lawsuits under federal and state wage and hour laws. His practice focuses on representing employers in a wide range of workplace matters, as well as preventative advice and counseling. He's successfully defended wage and hour audits conducted by the U.S. and New York State Departments of Labor, and he regularly handles cases before courts and administrative agencies involving claims of discrimination, sexual harassment, and retaliation. Please welcome back to the show, Principal at Jackson Lewis, Brian Shenker. Welcome, Brian.
Thanks for having me, Mike.
All right, so what's the big news with the FTC as it relates to non-competes?
Right. So, as you stated, for years, non-competes have been under attack, but really at the state level. This is the first significant, federal action we've had. And basically on April 23rd, 2024, the FTC issued its final rule, which broadly prohibits non-compete agreements for employees essentially at all levels. With only very limited exceptions. So specifically, the rule bans new non-competes with all workers, including quote-unquote senior executives after the effective date of the law. We'll get into that a bit more, the intricacies of the rule. But as far as the effective date, it's set for 120 days after the publication of that final rule. So as of now, we're looking at an effective date of September 4th of this year, though, of course, that could be impacted by legal challenges, which we'll also get to, as we've seen often when federal agencies are issuing employment rules these days. We do get legal challenges, and so there's often a delay. But
Brian, will the effective date be based on any non-compete that's out there, or does this establish a new starting point? So, can old non-competes for existing employees will they still be enforceable, or does this kill everything retroactive as well?
So, great question. With the exception of senior executives, and we'll get to who they are, that's a narrow exception, that yes, any non-compete that was entered into prior to the rule or after would be barred, right? Prohibited. So no, even if a company entered into a non-compete with an employee other than a senior executive, prior to the effective date, it will be unenforceable post-effective date. And so, that's very important to understand. Look, the FTC, they stated, some strong bases for this rule, though. From the employer standpoint, there are a lot of reasons, that there will be challenges. But really, the FTC found that non-competes, significantly reduce workers' wages, Their study, so to speak, or their estimate is that the final rule will increase workers' earnings by $250 billion per year as a result of the taking away of these non-compete restrictions.
250 billion. So is the assumption there that people were not able to take their take their industry experience with them and go get high paying jobs? They had to take lower paying jobs. Is that the rationale there?
Right, and yeah, so there are a number of reasons there, and I think right, one of them could also be that non-competes reduce competition for jobs, which certainly then keeps compensation down, and that
Right.
often jobs don't open up because as the FTC contends that an employee subject to a non-compete won't leave that, so there's less competition, less movement. It could stifle the creation of new businesses. Right. I think the FTC, believes this will, result in new business, startups from people otherwise, barred from competing with a prior employer. And they've also estimated that it'll grow over 8,000 jobs. So the FTC is identifying some big impacts as the rationale for putting through this final rule. Now, obviously, the FTC.
Stay on that one for a second. So it makes sense to me if you were prevented from leveraging your industry experience to go find another job, you might have to take lower paying jobs. So that makes sense. How this could result in more income for employees. It by having the non competes prevents people from competing for jobs, which gives the employer more leverage for a smaller talent pool. So that one makes sense. The last part you said, I'm not understanding how that one works. Can you say more?
Sure, you mean the creation of jobs and
Yeah,
businesses?
right.
Yeah, so I think what the FTC is assuming is that these not people subject to non-competes in the U.S. and they estimate again this will impact about 30 million people. Is that not only would these other people go to other positions, create more competition for positions, but non-competes also restrict individuals from starting their own business. So the FTC is viewing non-competes as something that's blocking new businesses that would hire additional employees. So I think that's how they're seeing that new business creation will
So
grow.
new business formation, that makes a lot of sense because people learn their craft working for someone else and then they go hang a shingle up for themselves and build their own business. So that does make sense. So whether you love or hate this new ruling, the justification is increased wages for employees and job creation. That's it in a nutshell, right?
Yep. And look, there are certainly employer concerns, right? How are we going to, protect our trade secrets and other important information? And we'll get to that, after we go through, exactly, what, compliance with this rule takes. But yeah, it's just going to be, an obstacle for employers, something that you need to understand. But as we'll discuss, it doesn't ban all restrictive covenants. And so there could be the use of non-disclosures, non-solicits, and we'll discuss, how those could be implemented to still, help, meet the employer's legitimate needs when
Yeah,
it comes to restrictions, but while also not running afoul of this final rule.
got it. Okay. Um, so maybe take us through more details of what the new rule says. What's included, what's not included, who does it impact, etc.
Sure. So, as we started off, the rule broadly bans non-compete clauses. And I think that, you know, as an employer, you should think of it as a non-compete clause because one of the things that the final rule points out is that we're not talking just about non-compete agreements. This can be anything that speaks to a non-compete found in, a handbook, an employment agreement, any policy document that that places some restrictions. So it's we shouldn't think of this as typically we have a non-compete agreement. It could be found elsewhere, but basically after the effective date. So right now that's September 4th. It'll be a violation for a company to enter or attempt to enter into a non-compete, enforce or attempt to enforce a non-compete, or represent to a worker that they're bound by a non-compete clause. And again, there's an exception here relating to senior executives.
So somebody has an existing non-compete in place, and the employee hears about this new ruling. Hey, I'm not bound to this, and the employer does anything to try to say no, this is only for new. This doesn't apply to us. You're still bound by this. You signed it. That's a no-go, punishable, I assume now.
Right. That's going to be a violation. And as we'll discuss, there's actually an affirmative obligation on the companies to notify employees or individuals subject to a non-compete that's already been entered into that will be prohibited by the rule, that you have to provide notification to those workers that their non-compete is no longer enforceable. So, right, it is very specific in terms of retroactive effect. And so really, if a company maintains a policy of, trying to enforce non-competes or, continuing to enter into them post effective date, that'll be, very problematic and, a violation here. But as I stated before, the definition of a non-compete is very important to understand, because we're not just talking about non-compete agreements. So a non-compete can be a term or condition that prohibits or a worker or penalizes a worker, or here's the real or functions to prevent a worker from seeking or accepting work after employment.
You had a very legalistic pause there, so tell us what that means.
Yeah. So, what does it mean? So, number one, the non-compete needs would be tied to termination of employment, right? So, if we're talking about a non-compete during the period of employment, that's okay, right? It's okay to say that workers can't compete with the company while they're working. That's in many states, there's a common law duty of loyalty. So this is really just focused post-employment. And what does this mean, right? The functions to prevent, right? So a worker from seeking employment. So, it's interesting, right? The FTC hasn't necessarily been clear on whether that's, an objective standard or a subjective standard, right? Meaning that objectively, does it run afoul of the rule if the provision actually prevents the worker from seeking or accepting employment? Or is it subjective in that if the worker believes that the provision prevents them from, seeking competitive employment, is that a violation? So some things we don't quite have answers to yet. We are getting guidance from the FTC as things go on. They just had a webinar the other day where they're continuing to provide some guidance. But, look, in terms of documents or terms that could contain non-competes, look, it's possible that non-disclosure agreements, right? So companies should take a look at their non-disclosure agreements, depending on the wording of those. There could be, wording in a non-disclosure agreement. This is an example the FTC has used that bars the employee from disclosing to any future employer any information that's usable or relates to the industry in which they work, right? And so something as broad as that could prevent that employee from going to work for a competitor, even though that's language found in a non-disclosure agreement. So,
can you give maybe some obvious extremes so we can understand the difference here? I'm assuming if I'm a machine operator, I've learned how to use a mill, and that's a transferable skill. And so you can't prevent me. I'm not sharing your trade secrets by using some mill or some lathe or some piece of equipment that is industry standard that manufacturer sells to plenty of other people. But how to manufacture a specific part that might require proprietary knowledge. Would that be an example of the separation we're talking about here?
Yeah, well, and that's a tough thing, right? Because trade secret protection is going to take a back seat to compliance with this rule. So, look, that's certainly going to become an issue, right? Where, like you said, a company teaches or trains, a mechanic or some person on how to operate a specific machinery. And, look, you could have a non-disclosure trying to prevent them from taking that knowledge elsewhere.
Yeah.
But the practical effect of that could potentially be a non-compete, something that's going to, be considered, a non-compete, functions to prevent a worker from accepting work after employment, right? So, that's why there's so many iterations of what could be, in non-disclosures that, I think it's very important for companies to look at their non-disclosures and not just assume, hey, this is a non-disclosure agreement, we're fine, it doesn't run afoul of the rule because it's not a non-compete. Look, if it's a, very, vanilla, bland, non-disclosure, not going too far, look, probably will be okay. But as we know, look, lots of employers like to work, better protections into their agreements. And so, right, non-disclosures could potentially be an issue. But there are other standard types of agreements or documents employers enter into that could run afoul of this rule too. Things like training repayment agreement provisions, where, again, depending on, rules of the state, the employee is agreeing to repay, certain retraining training costs, for example, if they leave, within a certain time period. Those are typically fine, but if the repayment perhaps is not, reasonably related to the actual cost of the training, the FTC has indicated it might find, a training repayment agreement to run afoul of, that non-compete ban. And of course, right, we discussed that non-solicits are probably going to be the focus of employers who want to maintain protections, especially, potentially over trade secrets. But, an overbroad non-solicit could potentially be, essentially the same thing as a non-compete.
Just at the highest level, you can't. It's going to be illegal, and it already is in some states. I want to talk about that in a minute. But it's going to be illegal nationally at the federal level, FTC, to have non-competes. So you can't prevent somebody from going across the street to your competitor. You can't prevent them from opening their own business in that industry. You can't prevent them from doing similar work and prevent them from keeping a living. So that's set. I'm assuming most non-solicit, non-recruit agreements, as long as they're relatively vanilla, are going to be fine. It's like, okay, yeah, you can open up a competitive shop across the street and compete against me using the knowledge you've accumulated over your career working for me, but you can't steal my employees and you can't steal my customers from me because you have that's an unfair advantage. Is that a fair general line?
Yeah, I think so. And look, and I think you're right. And so, look, I would know about, the ones I've drafted. I know, right, we don't go too far. Those should be good. But again, employers should just go back, take a look at it. because, having reviewed, restrictive covenant agreements from employers, in various disputes, look, sometimes employers get these, from attorneys, sometimes they're, getting them online or from elsewhere. And so you see a whole range of these. So I think it would just be good guidance to an employer that, you really need to consider and look at any restrictive covenants you have. Don't just assume those non-solicits will, pass muster.
Can you give an example of something that you think is probably too far?
Yeah. So look, I think in terms of a, non-solicit, they're often tied to the facts of the case, right? But you could see a situation where we're talking about a specific geographic area, and essentially the non-solicitation of clients or customers, based on what that employee it could basically restrict them from working in that state, right? Maybe the company they're coming from services almost as a monopoly, right? Or deals with most.
So maybe my restriction could say you can't call on our existing customers that you directly work with for a period of time, but it can't go so far as to say you can't call on any customer in this state because we're the number one provider of X in this state, right?
Right, and we've contacted those people already. You can't, right, and that's why, very much I like non-solicits that tie it into, sometimes you put in the last, 6 months or year of your employment, the customers that, you solicited during that time, right? Those are the ones you can't go. So
I know we could come up with a million edge cases, but is it safe to say that the non-solicit, non-recruit, it's really two buckets? Yes, you can go across the street and start your own company that competes against me, but you can't steal my customers, my employees. It really is those two things primarily, isn't it?
Yeah, absolutely.
Yeah. And so let's talk about each of those individually. Customers. Where do you think the courts are going to land as these edge cases get litigated? You can't steal my customers. It's okay. Well, your customer, they saw my ad and they called me. Or maybe I did proactively try to get them, but it was after a reasonable time period. Where do you think the lines are going to be drawn there?
Yeah, so it's interesting with non-solicits, right? Because the state and federal trends have really focused on non-competes, and so oftentimes non-solicits are looked at a tier below that, and they're subject to pretty good enforcement, more so than non-competes, because oftentimes and again, this is very much state dependent, but oftentimes courts are looking at it's a less severe restriction, and so it's found to be more reasonable and enforceable. But yeah, I think when we're talking about those non-solicits, it's really the question that a company should really ask themselves is, is this agreement, are these provisions going to preclude this person from working in this industry? If it gets close to that area, then it's getting potentially into that gray area where it might be considered a non-compete term. But yeah, I mean, certainly companies should not be afraid to use non-solicits and non-disclosures, but just, we need to be, aware that you can't use a non-solicit, as a disguise, not.
Yeah, I could see that, because I could say, okay, no, you're free to work and compete against us all you want, but you just can't call on these 15 customers. Well, maybe it's such a niche industry that 15 customers is the industry, right?
Right. And so that's why oftentimes it's, very fact specific when you're talking about that, because, the geography of where this industry is, where the customers are, that all, is taken into account. So it's tough to say those, broad suggestions, without having those facts. But, that's why you have to consider it and understand what the practical impact is of the restrictive covenants that you're going to enter into or seek to enforce after the effective date.
Yeah, right. It would seem to me a little more hairy. Just my own personal life experience. Um, it seems that when people are going after customers, that's a little more egregious, and pretty common to see a cease and desist kind of situation. Quit calling on our customers after people just left and trying to steal business away. It's the employee area that seems to get more gray. Very common, you hire a great employee, a great manager maybe, and they left their employer for a reason, and all the employees there liked that manager, and they also share the same reasons they might want to leave that employer. It's like, okay, these guys are calling me. I'm not recruiting them, but they're coming to me. It's like, how would you advise employers to think through situations like that?
Yeah, I think, I mean, look, it remains to be seen, but I do think that non-solicitation of employees could potentially run afoul of this, right? Because one could argue, that could prohibit a worker from, or prevent a worker from, accepting work, right? If, or seeking work. It's, a tough spot to say, but yeah, I think that's certainly something that could be a concern under the rule. One thing that I think employers can do, and this happens from time to time, is that employers enter into garden variety, these kind of garden variety situations, right, where basically what they're saying is it's not a non-compete, right? It's a garden leave where you're basically paying someone to not work, right? Where it's the person is going to stay home, they're getting paid, they're still an employee, and so that's fine. So under the FTC's preamble of this final rule, they've indicated that that type of leave and situation could pass muster, as long as they're still an employee. But that can raise the issue, right, of you're paying, let's say you've agreed, we're going to pay you for 3 months to sit at home and do nothing, right? It's almost a form of a non-compete period, but they're still an employee, so it wouldn't run afoul of the rule. But then you wind up in a situation where, what if that employee then says, all right, I quit, I'm going to go work for a competitor, right? Well, now you can't bar them from doing that because you can't do a non-compete. And, what would be the remedy there? You don't have to, is the remedy you don't have to continue paying them for, sitting around or something else. So, there are some unanswered questions. There are some creative solutions, that employers can, start thinking about here. But, I think we're going to certainly get more guidance as this goes on, because there certainly are, unanswered questions, with respect to what type of, restrictions really do violate the non-compete definition.
Lots of gray area, but I think we get the basics here. You can't prevent people from working. You can have non-solicitation, non-recruiting. It's primarily, I mean, there could be other buckets, but the big ones are going after customers, going after employees. And you can probably still do those things that I'm sure that they'll be tested in courts where the lines end up being drawn. But for the most part, your non-solicit can't inadvertently become a non-compete, right?
Right.
So that makes sense. What about exceptions? You mentioned an executive exceptions. Maybe rattle off. Are there specific categories here?
Yes.
Absolutely.
So there are a few exceptions that we should get into. And at the beginning, you heard me say the term senior executives. That is one exception that we can go through now. There's another exception to the non-compete rule involving the sale of business. And so those are the two biggest ones. So, starting with the senior executive exception, right? So what the final rule says is that you cannot enter into any new non-compete agreements with all workers following the effective date. However, if the company entered into a non-compete agreement with a senior executive prior to the effective date, that can still be enforced after the effective date.
So there is a grandfathering for senior execs, but even with senior execs, the go forward, you can't do new ones. Is that right?
Right. Exactly. Okay. So, and look, we're still in the period, pre, effective date. So conceivably, companies could even enter into non-compete agreements with these senior executives now that would still be enforceable.
Right. Right.
That could be a strategy, but this is a more limited exception than one might think. The term senior.
I was going to say, clearly this can't be good news. You just got a promotion. You're now a senior executive, right?
And, right.
You can't work in this industry to infinity, right?
Right. No, and that's why they've really made this a very restricted exception. So number one, for someone to qualify as a senior executive, they need to earn over $151,000 a year. So number one, that's a high level. That includes most compensation. However, the FTC on their recent webinar, they just indicated that there's certain compensation that wouldn't necessarily be included in that 151, which it could potentially not include payments for medical insurance, contributions to retirement plans, or other fringe benefits. So we'll have to pay attention to that because, especially when we're talking about high-level employees, often.
Do you think it would include commissions? Because this is obviously a good job and high paying job, but there's lots of sales positions that make more than 151. And I don't think of all sales reps as senior execs. Some are, but not all.
Yeah.
Make that kind of money.
But here's the catch, right? So in addition to that 151, the other requirement is that this person be in a policy making position. So the FTC is really envisioning very high level, like the CEO, or another officer in the company who's making decisions that control significant aspects of the business.
So that's the big one. It's policy making. So you could be at a is it an either or is it an and? Because I could see you're at a startup and you're employee number 3 and there's only 5 of you. Everybody is a policy impactor, but maybe you're not making that much money yet.
Right. So it is an end. So, right, you need to both the compensation and the policy making position. And look, I think this is going to be one that is construed very narrowly. But I think companies would be, well suited to look into this and try to determine, which of their, executives could fall in this, because certainly, there's only a limited amount of time to, if you don't already have a non-compete with such an individual, to enter into a new one. So, that's a potential option. Again, it is an exception. Not, it's really going to be our top level people, in the organization.
Yeah.
And then, look, the other exception, the other big exception under the rule is that this ban on non-competes does not apply to a bona fide sale of the business, right? So if you're a business owner and you are selling, your ownership, some or all of your assets in the business, that you can then be subject to a non-compete, right? Oftentimes, right, you buy a company you don't want the person who sold it to you going out and opening up a new competing business, right? That's part of what you're paying for. They're the goodwill of the business, and if that person goes and starts a new one, a lot of the value of that deal is potentially gone. So,
Right.
this is a good exception for employers. In the proposed rule way back in 2023, there had been they had a requirement that the person be at least a 25% owner in the company. Now that's not required. So, I could own 1% of the company when I sell it, and then I'm permitted to be subject to a non-compete following.
So, but only for greater than 25% owners. So, like a real
So
life.
that was in the proposed rule. That's not in the final.
Okay. So some use cases I've seen plenty of times. A business buys another business, and the owner. I've seen it where owners, I'd say, didn't necessarily play nice, and they participated in kind of pulling customers away and bad mouthing. Oh, these new owners are terrible. Um, it seems probably that kind of a non-compete is going to be covered, but I've seen probably the greatest damage is employees who leave. Hey, I'm not on board with this arranged marriage. I hired on with this firm, not the acquiring firm. And they're the ones that are peeling customers off and taking employees with them, and a business can evaporate pretty quickly.
Yeah.
What?
No, you're absolutely right, and that is something, right? You can this exception does not extend to the employees. And that's a good point. And that was something that was specifically pointed out, that in the sale, it's only applying to the buyer could only require the seller, the owners of the selling entity. But look, there are and look, there are some unanswered questions here, because one of the things we often see with the sale of the business is that one of the the selling owner, right? They often are stay with the business, right? That there's an agreement that they're going to stick around and work for the business for a couple of years or 6-month periods, something like that, to help transition. So we often have agreement, non-competes that say that have this employment related tail that say the non-compete will be for a period of 6 months from termination of employment, or 3 years from the closing of the deal, right? And that probably doesn't work, because there's a tie to the termination of the employment for that for the seller. So it can be interesting. I mean, look, there are other issues when it gets to the ownership, right? Some companies have phantom stock, right? Now, for the record, I'm not a corporate attorney here, but I have some knowledge of these things. So phantom stock is it's basically shares of stock given to employees, typically, that doesn't involve ownership of the entity, but the shares provide other benefits. So there's there could be a question of whether you have to be an equity owner, or would an owner of phantom stock who is selling the phantom stock be permitted to have a non-compete. So there are lots of questions here. And sometimes there aren't answers. I mean, again, there could still be restrictions under state law, for some of these that might tell us yes or no, where the FTC rule doesn't address it. But with the sale of business, there it's a good broad exception, but there's still going to be many questions as to what can occur there. One other exception I wanted to note, Mike, is that if and this isn't necessarily an exception per se, but it's the ability to enforce violations of non-competes that occurred before the effective date.
Okay.
Meaning, assuming September 4th is our effective date,
Yeah.
if you're an employer and you have an employee subject to a non-compete, and in August of this year they violate that non-compete,
Yeah.
you can go after them for that, right? You can pursue an action in court, a remedy. That's fine, and even if that continues after the effective date, that's fine. You can still enforce a violation of a non-compete that occurred before the effective date.
Okay. That makes sense. You made mention, Brian, about other areas like nonprofits and franchises. Are there special rules for certain industries or business classes?
Yeah, so potentially, right? Potentially there are some other issues such as, right, not nonprofits is one, right, where the FTC has jurisdiction over a lot of things, but they don't necessarily have jurisdiction over nonprofit entities. And so, an area of ambiguity, and likely an area that will be something that will be challenged, is the extent of the applicability of this final rule to nonprofits. Um, they typically would not be subject to the FTC Act as a nonprofit, but it appears that the FTC is taking a position that even if an entity is registered as a nonprofit, that it could still be subject to the rule if it's engaged in profit making enterprises or profit making members. Now, without getting into all that, what I think we gather from this is that the FTC is probably referencing many healthcare companies with this that may technically be nonprofits, but they may want the scope of this to apply to them. So we can see that we'll probably see, as time passes, various issues within specific industries. But
Sure.
nonprofits are certainly one. We look forward.
And
to
that's interesting. It's because most nonprofits, maybe it's not. I don't know. I was gonna say most behave an awful lot like regular businesses. That's not totally true, but there are plenty that do. So it's probably not most, but there are certainly plenty that do. But it's simply because the FTC does not have authority over nonprofits.
Right.
That's really
right.
interesting. Yeah.
And then another one of the issues that comes up here is non-competes between franchisors and franchisees, right? And so the FTC has indicated the rule will not categorically ban non-competes between a franchisor and a franchisee, right? So we're talking about the franchisor, the national company, and the franchisee, which runs the local retail store. And the franchisee is agreeing, right, we're not, the owners, they're not going to compete, outside of, the ownership of that franchise.
So if I'm McDonald's, I can still prevent my franchisees from setting up Burger Kings?
Exactly. So that's why, the FTC has excluded the franchisee-franchisor relationship. That said, they do note that franchisor-franchisee non-competes may present some concerns that could run afoul of state laws, antitrust laws, or the FTC Act. But they haven't, besides that general caveat, they have not indicated that they'll go after those.
Got it. Any other major exceptions we should talk about here?
No, I think those are really the major ones that we just went through, between the senior executives, the sale, these franchises. That's.
Let's talk about enforcement. So, how does this get enforced? What bad things happen to people who don't comply? And we probably have probably have some good models. Look at California. Like I don't know how long has California outlawed
Right.
non-compete, and
Yeah,
so
it's been a little bit now, right? Now, I think the only difference here, right, is that this is coming from the FTC. So, I mean, basically, if a company violates this rule, then it's a violation of Section 5 of the FTC Act.
okay,
Um, and so, violations of the FTC Act, right, that'll go before the FTC, and that can result in fines, penalties, injunctive relief, right? So if a company's, issuing non-competes or doing it right, you can get an order saying you can't do this. You're barred. You're prohibited from doing this, and any violation of this, will subject you to further, penalties.
yeah.
So I think it's unclear at this point, exactly the extent of these penalties, exactly, what they will entail for, different violations.
Brian, is it safe to say though that FTC is not going to come knocking on your door and do an audit like like immigration or the Department of Labor? They actually could, and it happens. Probably not getting random FTC audits. Is
No,
it safe
that
to say most?
yeah, I
I
wouldn't
assume most
expect
of these
that.
things are going to manifest where an aggrieved employee, whether they're right or wrong, they're going to hire somebody like you to come after the employer in this thing. We see it unfold in court, probably, right?
Right, right. And to be clear, someone like me who represents employees, not someone like me who represents
Yeah.
employers.
I'm lumping all you evil lawyers into one bucket. Yeah.
But yeah, that's essentially what would happen. I mean, the FTC in general, the way they operate is they're complaint-based agency, right? So, an individual, a consumer, whoever it may be, comes with a complaint. It gets investigated, handled within there, and there's a resolution. So that's typically how the FTC operates. So yeah, that's how we
Okay,
would see
that
this
makes
work.
sense. That makes sense.
Um, but yeah, it's going to be interesting. I mean, once the effective date comes, there's no honeymoon, right? We're essentially in the honeymoon period right now. There's no period of time once the rule becomes effective, that the FTC will look the other way.
Brian, I don't want to unnaturally scare folks about what the risks are here, but like this, I assume we can use California as a good example because it's non-compete's been illegal there for quite a long time, and so clearly there's going to be cases where employers violated, employees sued or reported. What kind of costs, what kind of impact are we talking about here? And it's probably too early to be too super specific, but
Yeah.
I want people to get a sense for like, okay, you know, are we talking $100 fine? Are we talking $100,000 fines? Are we talking these things are really expensive to defend? I mean, give us an
Yeah.
idea.
So, I mean, look, I think that there are a few things that we'll likely see, right? One is that what we'd expect is that you're not going to have one-offs, right? That if you have non-competes that you're entering into your post-effective date, you likely didn't do it with just one person. So
Right.
I think that's one thing to consider, that often these violations of the rule are not going to just apply to one employee. It could apply to a whole category of positions at the company, and we're talking, it could be 10, it could be dozens. And so you might not be dealing with just one violation. It could be multiple violations. So I think that's something to consider. Look, there is a good faith, I believe it's a good faith exception, in the rule. And I think that is, mainly tied to the senior executive issue, right? Because senior executive, if you've in good faith, um, made the determination that who's a executive and who isn't, that they're not going to try to necessarily kill you on that. I mean, certainly it could be a violation, but if the company has a good faith belief that the rule is not applicable, then they might be able to avoid a penalty in that situation. Again, we're not clear on what needs to be shown in terms of good faith belief. If we look at the Fair Labor Standards Act, that could require a company to seek legal advice in order to take advantage of that. But certainly, I think when it comes to identifying senior executives, documenting the process and why you're making the determination who is a senior executive, so that if you get it wrong, you might be able to take advantage of that exception.
Got it. Let's maybe wrap on let's be proactive. What should employers do? I mean, right from the jump, the old, see if I don't butcher the phrase, train your employees so they can go anywhere they want, treat them well enough that they'll never want to leave. That seems to really apply more than ever in this new world. What would be your guidance for employers other than, hey, you can't do non-competes anymore?
Right. So, first off, use this time wisely, right? We often say it, but 120 days is not that much time to prepare. Don't assume any of these litigation challenges are going to be successful. Until you hear otherwise, presume September 4th is the deadline.
Yeah.
So what are we doing? Review your agreements. And, again, not just agreements with employees, with independent contractors, right? Anyone who's subject to a non-compete is covered. So, this could be, anyone. And as we discussed before, don't just look at non-competes, right? Look at non-solicits, non-recruiting agreements.
Brian, you're reminding me of something that I skipped over here that we needed to talk about, which is notification. So this can't be sit on my hands and do nothing until September 4th, and I'll just deal with that. Because if you have them in place, you have to notify here, right? So there actually is something that is very actionable for employers.
Yes, exactly. So what companies should be doing with respect to that notice requirement, right? Ensure you have up-to-date contact information for your current employees, right? And look what contact information you have available for your former employees. Get that ready, because you're going to have to send out notice.
So say more about that. So it makes perfect sense to me. You got to notify your current employees. You probably have contact information from them because they're getting paid. What's the requirement for former employees? How far back do you have to go?
Right. So as long as you have their contact information, they should be notified. So if they're still subject to a non-compete, so look, if you have a restrictive covenant that had a non-compete for 1 year and we're 3 years down the road, right, you don't need to notify that person, presumably, because by the terms of the non-compete, they'd no longer be bound by it. So,
got it.
I think ideally
you're obligated to notify anybody who's impacted based on the rules and that you laid out in.
Yeah, presumably, because what the rule says is that by the effective date, and so that's the key, right? By the effective date, you're providing this notice to any employees who entered into non-competes that would be rendered, unenforceable by this rule. So, the assumption being, if it's already unenforceable, then because the time has lapsed, right, and the period of the restriction no longer is here, it's passed, then this isn't making it unenforceable. It's already unenforceable.
So for the small business owner, 15 employees with low turnover, maybe you had these in place. That probably not a big task. You're a bigger firm. You've got a large sales organization where non-compete was always a standard part of a sales your onboarding process, and you got, pretty common in the sales organization, maybe a 30% turnover, 15% voluntary, 15 involuntary. And it says you can't compete or steal our customers for 3 years. You could be looking at a lot of people that you've got to go notify.
Yes. And so luckily though, the notice requirement here is a little more flexible than the notice requirements in many other statutes. So it's it doesn't have to be mailed. So it could be delivered by hand. It could be mailed. It could be emailed. There's actually an option that the FTC explicitly says you could text the notice. That said, we would not recommend texting the notice, and that's something that can easily be overlooked. But the FTC has model language out there for this notice. And look, what a company could really do, you don't need to send it individually. You could blast it out to all these workers. It's okay if you're overbroad and send to someone who's not subject to a non-compete that you're no longer subject to, right? That's not an issue. So you could send a broad notice, and that's probably not ideal. But I think the key would be is if there are any senior executives that are subject to non-competes, you will not send them that notice because if they've entered into a non-compete, they can still be bound by that. Sure. After the effective date. We just can't enter into a new one. So you don't want to notify the senior executives, or else you're taking away the non-compete when you didn't have to.
Yeah. Brian, any guidance you have for employers that is not legalistic? It's more the softer side of HR, if you will. Probably be offended when I say the more human side, but I mean, there's black and white of the law, but then there's just how you treat people and build a culture of both accountability and performance, but also relationship and trust, right?
Yeah. So I think the first companies should really start this process by identifying the business reason, the justification for these agreements, right? And many times companies just do this because they started and, doing it, and they just go along with that practice. But, think about whether the restrictions you have in place or want in place are reasonably tailored to those justifications for it, right? So, and then look at the hierarchy of agreements, right? Will a non-disclosure be sufficient? If not, will a non-solicit, then help? Obviously, non-competes are going to be off the table. So, thinking about, what we can do to meet our goals. And that's why, look, oftentimes when I speak with clients and we go through why they want to non-compete and what they need to protect, we wind up reaching the point where we don't actually need a non-compete because maybe all they needed was a solid non-disclosure and a non-solicit of, clients or something like that. So, consider alternatives. And I think there will be a trend towards almost the reverse of how we've looked at the issue of restrictive covenants, that instead of having this thing at the end of employment restricting them, I would expect more employers to focus on making compensation contingent on continued employment, right? Retention bonuses, and other incentives for employees, workers to stay at companies. So, I think, employers don't despair, right? Non-competes will be generally off the table, but you do have other options. You just need to take some time to consider what those are. And that's why, that work should start now, because, this isn't something you want to be scrambling to, get together, at the last minute. Use the time you have now. If the effective date gets pushed out, then just put it on pause, and at least you've done your analysis and you've figured out potentially, how you will comply when the time.
Yeah. You know what? And I think maybe my guidance for folks would be there's a sea change that has just been going on for a few decades now, and it's just accelerating. There's a shift in power from employer to employee. And I'll say it's largely based on supply and demand. We're at what 3.7, 3.8 unemployment, under 4% for a couple of years. It's been decades since we've had that, and it's based on birth rates from 30, 40, 50 years ago and the supply of the workforce. There are employees have choices like they've never had before, and they vote with their feet. And so employers are going to have to be more accommodating to employees, less restrictive of employees, just surely to compete for the talent pool. And employees, they put people in office to vote for laws that they like and protect them. And I mean, we thought we were a kinder, gentler nation. I know it wasn't that president who said that, who implemented this, but when COBRA first got enacted, we just did a podcast recently on COBRA. It's like, you know what? You can still choose your insurance. You can't get kicked off insurance when you lose your job. It might cost you $1,500 a month. It's not like it's free or anything, but we thought that was like a big, wow, some new benefit. I mean, from fair chance laws to leave laws to now today's conversation, non-competes, I think everybody needs to understand this is part of a continuum that is not changing. The laws are going to continue to take power from employers and give it to employees, and provide them more protections. So as an employer, small or large, whether you love it or hate it, get on board and build an employment strategy, an employment brand that embraces it.
Couldn't have said it better myself, Mike.
Yeah. Brian, anything you want to say in closing?
No, I think you just put it in a great way that, look, this is what it's going to be. You got to, develop a strategy now and don't wait. It's coming. There are ways to still protect your business's information and other things. It's just going to take a little more nuance and a little more thought than just throwing out, a broad non-compete. We're going to have to think through things and take advantage of, what restrictive covenants are left and other types of agreements.
Yeah. Very good. Always enjoyed talking to you, Brian.
Thanks for having me.
And thanks to everybody else for joining today. If you learned anything today, if you got value from today, I encourage you to like, comment, and share this episode. And please subscribe, whether it's on YouTube or the platform of choice, wherever you consume your podcasts. Until next week, we'll see you then. That's it for this episode of Mission to Grow. Thanks for joining us today. For show notes and more episodes, visit us at missiontogrow.com. If you found this content valuable, I invite you to share it with a friend and subscribe to the show. If you really want to help, I'd love it if you left a 5-star review on Apple Podcasts, YouTube, or wherever you listen. Mission to Grow is sponsored by Assure. Assure helps more than 100,000 businesses get access to capital, stay compliant, and develop the talent they need to grow. To learn more about how Assure can help your business grow, visit AssureSoftware.com. Until next time.